So before we get started, just wanted to acknowledge our sponsors again. You see the folks up there, Amwins Brokerage of Florida, Markel, Midlands, York, Dean Ringers, Morgan Lawton, Walton, Lantef, Schroeder, and Carson, Hurley, Rogner. We appreciate everybody's support, all of our sponsors. We couldn't do this without their support. So without further ado, we'll get going with our next session, which is our attorney panel. Our panelists today, we have three esteemed panelists here. We have Berta Fandiño Guerra. She is the founding partner of Fandiño and Carballo. She has a specialization in workers' compensation. We also have Josh Walker. He's a shareholder with Dean Ringers Morgan Lawton. Focuses on general liability and commercial litigation. Josh is also a veteran of the armed forces and retired after 21 years of service. Thank you for your service, Josh. Christine Kennedy. We also have Christine Kennedy with us. She is a partner with Cole Scott and Kissane. You're usually accustomed to seeing Bernie Probst up here. And Christine is a colleague of Bernie's, I believe. So Ms. Kennedy is a past president of the Orange County Bar and specializes in employment practices law. So with that said, we'll go ahead and get started. So the way we usually do these is we have some preset questions that you see up there, but the idea here is to get questions off the floor. And obviously we have legal counsel here, and so yeah, please take advantage of it. So before I get going and throw out one here, is there anyone that has something they'd like to kind of put out on the floor? Obviously, the three major disciplines that the three panelists have are the workers' compensation, general liability, commercial litigation, and then employment law. So anybody want to get us going, or can we pick one off the slide? Good.
I'm not sure this falls into what you're talking about, but the new law regarding healthcare, health insurance and associations, is there going to be any changes to how that gets handled?
Now, is that the association plans for group health insurance? Are any of you guys familiar with that? No. Probably.
No.
Now, I mean, just kind of going on background, I don't know a lot about it, but the association plans are a rule that the current White House administration changed the Department of Labor rules to allow for association plans to exist, which basically means that an association can get together and purchase health insurance, band together and purchase health insurance, and it essentially mitigates a lot of the requirements under ACA. Now there are a lot of nuances in terms of how and what can fit and what's considered homogenous or what's considered an appropriate association, if you will. So there's a lot of that. It's pretty recent regulation. It's very, very recent. So it hasn't, I think we only know of a couple of health insurance carriers that have even announced an interest in supporting such a thing. So that's going to be an obstacle, is how the health insurance companies and markets respond to this. But I think that's as much as I personally know. So hopefully that helps some.
I'm not sure if anyone on the panel might be able to address this, but in our area, we're seeing a little bit of an uptick in civil discrimination claims. So that's a new type of claim for us. That's coming more from the customer side and similar circumstances to what they want to start about.
Yep. So the question was civil discrimination lawsuits coming from customers and allegations, and how, I guess, from a coverage standpoint or from a liability standpoint. Any thoughts on that?
Yeah, and obviously I practice employment law, but there is overlap on discrimination cases to the public too. It's going to be sort of the same thing where with employment law, you want to make sure you're training your employees to avoid discrimination, and that includes to the public, to the guests, customers. So you have to have these policies in place. It's why it's so important to have those policies in place in order to train managers and employees on anti-discrimination. I don't know if that answers.
Well, is that coverage offered under, I guess, employment practices liability, or is that more a general liability?
You know, I have had some cases that are covered, and I can't tell you for sure whether they were an EPL or if it was a D&O policy, but I've had several that have come in, public accommodation discrimination types like that are covered.
Yeah, this topic area obviously covers quite a broad spectrum. I'll tell you a couple of the trends that I'm seeing in my practice. One of those, exactly what I think is to your point, the civil discrimination claims. So a lot of you may have heard the situation of the baker, I think in Colorado, that objected to baking a wedding cake based upon his religious beliefs because the wedding cake was for a gay couple, and his religious beliefs, he said, prohibited him from doing that. And he lost, and that went all the way up to the Supreme Court. And you may have heard recently of the ruling that came down there that reversed a lower court ruling and essentially said that this particular baker had the right to exercise his religious beliefs, and if that means that he didn't feel comfortable within the parameters of his belief to bake the cake for the gay couple, then he wasn't required to. That ruling for the Supreme Court was very narrow, however, and so it didn't preclude these types of claims being made against other organizations. So for those type of claims, what we're seeing is still a lot of uncertainty, quite frankly, as to what the law requires, what it prohibits, particularly when you get into the gray area of someone exercising their religious beliefs and the impact that has on others. From an organizational standpoint, and she's absolutely right, the best thing to have is clear, defined policies that we do not permit discrimination of any kind whatsoever. That's going to protect you from the organization point, and it will also give you some distance when you have rogue employees that are going against your policies. But another type of discrimination claim that we're seeing a lot of, and one that's worth mentioning, is ADA discrimination claims. There's a new wave that's coming through Florida now for your websites. And if you haven't seen these yet, and I believe some FIT members have, if you haven't seen them yet, beware. There's a couple of law firms starting in South Florida that are working their way up northward that are suing organizations, both private and public organizations, if your website is not ADA compliant. And so there's a couple of things they look at. One, you will see a deaf person who brings suit against a company because there may be video content on the website that's not closed captioned. And sometimes that video content may go back for many years that's not closed captioned. So they will bring a lawsuit requiring you to close caption the videotape content on your website. They will win that lawsuit. The law is trending more and more in favor towards providing these types of protections. It is a bit of a shakedown. We see these same attorneys that come through, they file the identical complaint. They will require you within 6 to 9 months to make your website ADA accessible. Depending upon the amount of content, that may cost you $30,000 or so a year if you have a lot of content on your website. And then they'll demand a quick settlement for $10,000 for their attorney's fees. They've spent probably 3 hours working in this particular case. They're going to win that, and it is an attorney fee driven claim, meaning the more you fight them on it, the higher their attorney fee demand is going to be. So you have those from the deaf individuals. Then you also have the blind. And the blind plaintiffs are coming in saying that your website must have the proper coding behind it so that the software on their side of the screen can read aloud the content. So if they move their mouse over the website, that it needs to be able to read it aloud. And if you don't have the proper computer coding on the back of it, then it's not going to allow that. So that's another different type of discrimination claim, but just be on the lookout. If you haven't seen it yet, you probably will. And it's worth looking at your own website and talking with a professional about what the requirements are. If anyone has a question about some of the contractors that some of my clients have used to try to bring their websites up to ADA accessibility, please feel free to get with me afterwards and I can give you some of that information.
Actually, there's I'm aware of, at least since we have a lot of public entity clients, there's at least 15 that have pending lawsuits right now, exactly what Josh is mentioning, and it is one of those plaintiff-driven deals. So yeah, definitely need to be careful with that. Any follow-up questions on that subject? All right, we'll probably change this up. I think go focus on workers' comp for a quick second. It's not a necessarily a question up there, but it was coming to mind, volunteers and workers' compensation coverage. So, Berta, if we had a volunteer, one of our nonprofit organizations, that happens to get injured while helping at a fundraiser, gala, whatever it may be, how does the workers' compensation respond, if at all, and what liabilities does the employers have towards that volunteer?
Well, depending on how the volunteer, depending on your program, the volunteer will be covered by workers' compensation, and you may have to provide the same benefits to a volunteer that you would to an employee.
We'll switch up. Any follow-ups on that as far as volunteer coverage? Because a lot of commercial insurance carriers do not offer coverage for volunteers under workers' compensation. So just be mindful of that. FIT, of course, we've amended it to include volunteers. Dave?
Speak specifically to how it coordinates if the employer also has an accident policy that picks up volunteers.
Sure, this might be in the general liability realm. So oftentimes the accidents that we see that involve volunteers include auto claims. So you may have volunteers that are driving your vehicles, or you may have volunteers that are injured on your premises. Normally, that will all fall under your general liability policy or your automobile policy. You probably have med pay. A lot of you probably have med pay as part of your coverage. So if someone's injured on your premises, including volunteers, the med pay would kick in to pay for that. Your automobile coverage would provide that, particularly if there's UM benefits. So if you have uninsured motorist coverage for your vehicles and you have volunteers that are in those vehicles and they get injured, then they can make a claim against the uninsured motorist coverage for that.
Now the accidental.
Fair warning that involves someone who's in the room in a recent situation. A volunteer is working in a classroom with children, and the volunteer gets hurt. No auto exposure. We have an accident policy intended to pick that up, or workers' comp by our policy also covers.
I agree with you 100%. I think the exposure to you is higher if you put that through your accident policy than if you put it through your workers' comp policy, because the benefits are delineated and there's no pain and suffering under workers' comp, which is something they could claim under your accident policy. So you'd be better off keeping it under comp.
Now, if workers' compensation, the commercial market oftentimes doesn't offer or extend coverage to volunteers. So there's, say for example, there's a couple of carriers that come to mind. So comp options are what is now AmTrust. They do not automatically extend coverage for workers' compensation coverage to the volunteers. In that situation, with the need for the accident and death and AD&D, accidental death and disability policy comes into play, because it's not going to be picked up under comp. So you really have that policy there to rely upon. So I guess it will kind of depend, but that's an interesting question of if you have both, which way you drive it. But it sounds like workers' comp is the agreement here.
If there is workers' comp coverage for your volunteers and if benefits are provided to them, then typically you would be entitled to workers' compensation immunity. So they wouldn't even be able to bring a civil claim against you. And Berta's absolutely right. It would go through workers' comp, which is better for you typically than being exposed to a more broad liability claim. But if I may, yes. Oh, you do need both. And here's another consideration as well. What if your volunteer injures somebody else? Right. That's something that occurs quite frequently. Under Florida, there's the Florida Volunteer Protection Act, I believe it's called, that says your volunteers are typically provided immunity. So if you have a volunteer that's working at your premises and they injure somebody else, they're not civilly liable for that unless they acted in bad faith or with malicious intent, something along those lines. What that same statute says is that you are directly responsible for your volunteer's conduct. So if your volunteer accidentally hurts somebody on your premises, you're liable for that. Unless they acted outside of, I would say, course and scope, but the same analysis typically applies even with volunteers. So they acted with bad faith, for example, a criminal act. And in that case, you might still be responsible if you had some way of knowing, if you knew or should have known that this volunteer was likely to hurt somebody else. So perhaps you didn't do the required background check. depending upon your type of work that may be required by law. So the point to take away from this is it is important when you look at your general liability policy to make sure that it covers even that conduct by your volunteers that would ordinarily be covered if your employee committed the same act.
Any follow-up questions on that? Or? All right, we'll switch over to employee law for a second. I guess, employment practices has been a challenging area for nonprofits, just from a claim standpoint. So I guess, without even picking one of those questions, what are some of the relevant, cases that you're seeing now? There was a trend for whistleblowers for a while there, and what are you seeing out there right now?
Well, whistleblowers retaliation in general definitely continues to be a trend. We see that a lot. The hashtag #MeToo is now really getting things going on the sexual harassment front. I think the EEOC just published something yesterday announcing that they've increased the number of lawsuits that they've filed alleging sexual harassment. So that is really a big area too that we're seeing. But again, the retaliation is one that it seems to come along hand in hand with every other claim we see, whether it's a retaliation claim through the EEOC or the DOL has been investigating those increasingly too. Because there are so many different statutes that have different anti-retaliation laws. So you'll hear me repeat myself a lot in these things and constantly saying how important it is to have good management training and good policies in place. That isn't necessarily going to, make it not happen. It's not necessarily going to keep it from happening, but that's a good, helpful defense to, if you do encounter one of those cases.
Now, when it comes to volunteers, so volunteers making an allegation of some kind of employment violation, whether it be racial discrimination, whether it be, they should have gotten paid or they thought they were going to get paid or something like that. How does that fit into the equation?
Are you saying a volunteer?
A volunteer alleges retaliation or they were thrown out because of something or discrimination. Does that fall under employment practices?
Well, as far as coverage purposes, I have to tell you, I really am not sure if that is covered under policies. I haven't had that come up. I think with liability, I don't think that a volunteer would fall under some of those statutes, but that's an interesting question on the coverage aspect. And I don't know if you've run into that before, but and there may be some policies that do cover that. But as far as the volunteer themselves, if that's the alleged harasser, there's the same liability for the employees if a volunteer is in there as an alleged harasser. So it's important to have training for them too.
So, I guess, Josh, late reporting. So that's a top question there. When should claims be reported and the impact of late reporting? And guys, we, all of our agents, insurance professionals, everyone always says, report your claim, timely. But despite that, we still have an issue with this. So
I think every time that I've either spoken at a seminar like this or attended one, this is always something that's discussed. And so everyone here has heard this before, and you're going to hear it again. And the reason why is because no matter how many times it's stressed, the bottom line is sometimes claims fall through the cracks. Everyone here is busy, and you're operating your businesses, and you're managing your clients and your employees and finances with a constant stream of emails that are coming in. And sometimes claims just get missed. And sometimes you think that somebody has reported it, and it just falls through the cracks. So maybe the best thing to do is to highlight what are the risks of late reporting. Well, one of the major ones is you may lose your insurance coverage, right? If you have a loss that is not timely reported, the insurance carrier, when they do learn of it, may look at it and determine that as a result of the late reporting that there's been some prejudice and now you may lose your insurance coverage. But it goes further than that. If you do timely report a claim, particularly if it's a significant loss, a lot of times what may happen is the carrier may assign counsel to you early on. And there's a lot of benefits to having an attorney involved early on with a significant loss, because we can come in and we can help you investigate the claim. We can interview witnesses. We can help to preserve documents, including surveillance video and things like that. And in doing so, when you have an attorney involved, then you have pretty much guaranteed that your investigation is going to be privileged. And the other side's not going to be able to know the good, the bad, and the ugly of everything that you've uncovered in your investigation. Now, without an attorney there, if you haven't reported it to your carrier, and if you conduct a normal investigation that's not particularly driven by the loss itself, then the other side may have an argument that that's not privileged and it's discoverable, and they can find out who you spoke to and what you learned as part of that investigation. So if you report a claim early, not only are you preserving your insurance coverage, but you're also making sure that you get the benefit of the coverage that you pay for. You get counsel that can come in and help you investigate the losses that occur. And then the other issue is, what is a claim? What does it mean when you have a claim? Does that mean when you have an accident? Is that a claim? Or is it when you received a notice from an attorney that the person injured on your property has retained counsel? Or is it when a lawsuit is filed? And the question really is that it depends. From an insurance coverage standpoint, what the courts will say was, when did you reasonably anticipate, when did you reasonably believe that there was going to be a claim, a lawsuit, or a claim for damages related to the loss? And so it's really a fact question. It's kind of case specific, and it depends on each circumstance. But the bottom line is, there are a lot of benefits to you if you can report a loss immediately, and a lot of risk if you don't do that.
I think we both have.
Go ahead.
I would add that the same is true for a workers' comp injury. If you have an employee who gets injured at work, even if the injury seems minor and the employee declines medical care and it's one of those things, send it in as an incident only and report it, because it will affect your defenses. If you don't, it could even affect, you could even be penalized by the state for failing to report the claim on a timely basis. So I know sometimes it's easy to say it's a small thing, we can handle it in-house, let's not report it, but you're better off if you report the claim.
Yeah, I actually wanted to comment on EPL reporting. Before I do, I'm going to comment on workers' comp, because we deal on the EPL side, we deal with workers' comp retaliation claims a lot. And I've had a lot of employers who think they're doing themselves a favor by not reporting it. And that turns out to be a problem for your claims, but can also be a problem if I'm trying to defend a workers' comp retaliation claim where we have an employee who says they didn't want to report it. And so that can be a problem on the retaliation piece of it too. But on the EPL cases, the comment I wanted to add to that is more and more of those are coming to us pre-suit, with pre-suit demand letters from attorneys. And I see employers sometimes overlook those, and they don't think that this is a claim, or they think they can just deal with it, or maybe they'll just go away. So that's something that's really important to be on the lookout for, and making sure you report those, and charges of discrimination, same thing with pre-suit EPL matters.
Yeah, and don't underestimate the benefit of having the communications be privileged if an attorney is assigned early on in the claim, because it can really help you shape your defense and protect you from the other side if you can claim privilege.
Nice problems and issues.
Right.
Any questions on the floor? All right, well, workers' compensation, there's a question up there about drug testing and how that impacts a workers' comp claim. And to add another wrinkle to it, in light of medical marijuana, if an employee has a prescription for that, how does it all tie together?
Okay, I'm going to leave the medical marijuana aspect of the question for last, because that's really, really new, and there's not a lot of guidance on that yet. As far as the positive drug test, there is a defense under the Workers' Comp Act that if an employee is under the influence of a drug or alcohol at the time of the accident, there's a presumption that the accident was occasioned by the intoxication, the influence of the drug. It is a rebuttable presumption, but it's a high burden the employee has to overcome the presumption. They have to present clear and convincing evidence, which is a really high standard, to show that the influence of drugs did not contribute to the injury. Now, do you have to have a drug-free workplace in order to drug test your employees? The short answer is no. And can you deny a claim based on a positive drug test? The short answer is yes, you can, but The caveat is that you have to have a policy in place that it's clear and defines the testing is required for all employees. It has to be applied uniformly. It has to outline the consequences of a positive drug test, including termination, denial of benefits, whatever disciplinary action you're going to set out. If you have a clear policy and you notify your employees, then you can use that positive drug test to deny coverage. Best practices, make sure that you give the employees the policy and have them acknowledge it in writing and they are aware of it. Be mindful of the fact that the drug test has to take place the same day of the injury. If you send somebody for a drug test 2 to 3 days after their injury, you're risking your defenses on that issue.
I do have some good news on the medical marijuana piece. For the last couple of years, it's just been a big question mark. We don't know what it means or how it affects the workplace. Recently, the legislature has now adopted an implementation statute, and in one paragraph at the very end of it, essentially what it says is you as the employer can continue to have a drug-free workplace policy, and you're not responsible for any discrimination claims or otherwise if you prohibit people from using marijuana, medical marijuana. So even if someone goes out and gets a medical marijuana card and they have a physician that prescribes it to them, you can still have a drug-free workplace policy that does not recognize or allow your employees to smoke marijuana, despite what a physician may otherwise say. And it's contained in one paragraph at the bottom of the statute, of the implementation statute. And one of the things that comes up sometimes is FMLA. So let's say that you have an employee that goes out on FMLA and he's out for 60 days, and during that time he has a doctor that gives him a medical marijuana card, and he goes out and fills that and starts smoking marijuana, and then comes back and you drug test the employee and it's against your drug-free workplace policy, and let's say he tests positive. He hasn't been at work for 60 days. Can you terminate him? The answer is yes. And they cannot sue you for discrimination under the FMLA based upon that decision. So, or the ADA, or the ADA. So thankfully, we finally have some guidance now from the legislature that has been an open question for a lot of you. Now, this is still going to be tested in the courts, no doubt, over the coming years. But we are better now than we were when we sat here last year and we had no answers to these questions.
And also from the workers' comp perspective, if you have an employee who's received a prescription for medical marijuana, you have to consider whether you want to bring somebody who's under the influence back to work. Let's say they're released to return to work with restrictions. Do you really want to accommodate someone? And I don't think you have to under those circumstances.
So that could be treated the same way you treat pain meds, right? If you're on pain medication, you say, well, you can't come back to work, but you're done with that.
Correct. Yes.
It just needs to be consistent with your policies.
We have to modify our drug-free workplace policy that deals with prescription medication to address specifically marijuana, or is it just covered because it's a prescription at that point?
I believe that medical marijuana in the state of Florida is not considered a prescription drug. It's a recommendation, right? So I don't think, speaking from a general sense, I don't think you would need to modify your policies depending upon what your policy says. Now, best practices, it might be best to do that. And particularly as these things are now being tested in courts, it might be a good idea to do that. But right now, there's nothing that would require you to do that.
I would suggest you treat it as you would a controlled substance, something on a controlled substance schedule. So.
You talked about somebody, workplace accident, testing positive for drugs or alcohol. I've been in the insurance business for 30 years and I've never asked this question. At what level? I mean, you're legally drunk by the state standards if you're pulled over as .08. What's the standard for somebody under the influence? I mean, if somebody's at .06, I mean, is that intoxicated or more common issues?
When it comes to alcohol, they take the state limit. So if you're under the limit, I think you're in a better position as an employee to avoid having your claim denied because you don't meet the standard. Now, if the employer can show that the intoxication, despite of it being under the legal limit, is what occasioned the injury, then you might still be able to deny the benefits.
We operate inpatient units, and recently there's an uptick with visitors bringing firearms. What are the guidance around visitors bringing firearms?
The short answer is you can have a no firearm policy for your facility. So,
As easy as posting a sign that has the symbol.
yeah, yes, it is. Yes, it is.
Although, I'll just comment though, for employees, there's some exceptions as far as having firearms in their automobile, but that can depend too on the property, where it is, but.
Also depends if you're considered a school. Because if you're considered a school, then we actually have to happen. And you're not allowed to have them in the parking lot either.
Right. Good point.
Where do we stand on medical marijuana as far as like our clients go, if they're residents in our facility and they have the card?
Yeah, where do we stand on that?
Huh.
Good question. That's a real good question.
It is a good question, and we don't really know. But the question was, as I understand it, what if you have an inpatient facility and you have your residents who have a medical marijuana card and recommendation? Can you prohibit people who are residing in your inpatient facility from using the recommended marijuana at the facility? I don't know, quite frankly. I would think there would be a strong argument under the implementation statute that there can be no claims for that so long as you have a policy that is applied uniformly. And you can prohibit the consumption of marijuana at your facility. But quite frankly, that's something that has yet to be tested.
I did have it come up with a for-profit entity that is treating for addiction, and they were not required to treat it as just like any other substance, whether in the facility with or without the card, it's not allowed. The question was more the residential one, but in their case, it just treated it as this is not legal in Florida, and you don't have to do it.
Just say no.
I mean, I guess we.
I get to
Yeah, that's a good question. I guess we'll have to wait to see the real answer to that one. All right, we could switch it up here. I guess we just had a session right before this one about crisis media management, and of course we have a question up there about mass shooter incidents and coverage there on that. So I guess the question is, what's the advantage of having mass shooter, active shooter coverage, and how does that translate to any kind of crisis media response or coverage?
Obviously, this is a hot topic. It's come up recently. I've had involvement with some of these claims recently. And there's a number of things to consider here from a coverage standpoint. Recently, and I'm starting to see this with some school boards, they are starting to procure active shooter coverage, separate and apart from their general liability policies. The first thing to know is that there's no requirement that you do that. This is something extra that you can purchase if you want to. What I've seen for some of these coverage documents of what it applies that might be different or in addition to your general liability policies are things like property damage claims. So, for example, imagine a mass school shooting that occurs and there may be significant property damage. I mean, you may have bullet holes in the walls, for example, all the way to the point of having to demolish buildings. So the property damage claim alone might be very significant and might ordinarily not be covered under your property policy. So some of these active shooter policies may include a property damage component. What I've seen, the way that they're structured also, to include things like funeral expenses, counseling expenses for people who were impacted by the mass shooter event. And these are things that it's almost like a supplement to a med pay that would be available for some of these type of events. Depending upon the type of business that you run, nobody can guarantee against this happening at your facility, whether it's a disgruntled employee or something otherwise. But it's worth looking at these types of coverage and deciding whether it would be helpful to you. I can tell you there's another coverage that is afforded sometimes for public relations type of exposure. I can tell you, and I've dealt with this personally, it is very beneficial when you have a high-profile event. This really ties into what we just heard about in the last session, right? So you have the media that's immediately coming to your facility the day that a crisis occurs, and how do you handle that? Do you have a communications team that's ready and available and understands how to field the questions? How do you have a consistent communication strategy? Well, there's insurance coverage for that available sometimes. It will actually spend the money to bring on a public relations firm to help you with that process. And in this day and age, where so much is driven by what we hear and see online and on television, and the narrative is so critically important, if you can get out in front of an event like that and have a team that's available the second that it happens to help you manage the response, that will have a significant impact, not just on the immediate response, but also how it's perceived in the public, which ultimately would determine what your exposure is. How many lawsuits are you going to face related to this? If it goes to trial, what's the jury going to be thinking? What would they have heard for the last couple of years leading up to trial on some of these issues? So that's another coverage that you might want to look at if it's available to you, that would be very beneficial in handling these type of responses.
PR for employment claims, if any type of claim?
You know, I'm not sure. That's a good question.
I mean, the only reason I'm saying is, because I'll emphasize that too, and it's happening more and more with employment claims, especially if the EEOC gets involved, because they like to issue press releases. And I've had that come up with cases where, an employer I'm working with wants to get, a PR firm to help them out with getting the right message out there. So I don't know if there is coverage for that type of PR, but that would be good to know.
I believe, well, in the FIT program, we definitely have limited coverage for crisis management and response, and we've utilized it at least as necessary, and it's up to $25,000. But there are triggers. I can't go into all the details. Every event stands on its own. But as far as employment related, yeah, that's a good question. I'm not sure if that would qualify as triggering a crisis event or something like that, but that active shooter coverage policies often have a crisis management coverage component to them as well, which may be greater than $25,000.
So the active shooter coverage is now an added to the property policy. Is that a reimbursement for crisis management expense, or when claims call in, is the carrier that signing the crisis management?
So currently, FIT has, with the main the main general liability, professional liability policy, there is a crisis management component built into that already. The active shooter coverage is in addition to that. FIT essentially passes it to, it's Lloyd's, isn't it? Or I believe it's Lloyd's, or no? Hiscox is the carrier that we've got this package with, and it is part of the property, and it was not what it offers coverage on is the counseling services. It does have limited crisis management. It does have funeral services included in there as well. But as mentioned, it's more of a round out of the already in place general liability policy to add as an extension to the coverage already in place. Does that answer your question, Steve? We do have certain firms that we can go to. Actually, Markel, who is our reinsurer, has, and I forget the name of the firm. I think it's Firestorm or something like that, that they have as a approved panel. But that that doesn't mean that's the only one. Certainly, it is something that the FIT member would have an opportunity to say, hey, we have a relationship with such and such firm. And just like we handle attorneys from time to time as far as getting them added to the panel, we would follow the same process. In the event that you don't have one, then it would default to the firm we have naturally. Now, it is a good idea to go ahead and probably figure out who you would want to use if that situation would arise beforehand. So probably do it, just have that available, just like we have with attorneys as well. You guys have the attorneys that you're comfortable with. It's approved by FIT. All of that sort of stuff is already figured out prior to a claim arising. Same would apply to this crisis management company, is you would want to do that, and we would highly encourage you to do that. But in the event that you haven't had a chance to do that, we would still sort that out afterwards. But of course, it would just be easier to have it figured out beforehand. All right, well, I think we got probably time for one or two more additional questions. Anything on the floor? If I'll move to this. I think we're about 10 minutes away from wrapping up this session. So, well, I'll probably go ahead and ask another question here. I think, yes.
Questions up there. Does an employer have an obligation or responsibility to provide permanent modification duty to an employee upon MMI?
I think this is one that we encounter very often. We always are encouraging our employers to develop strong return to work programs and modified duty programs to bring people back to work when they've been injured. But what happens once that employee reaches MMI and the doctor assigns permanent work restrictions? Are you all obligated to keep that employee and provide permanent work restrictions? The answer is no. The workers' comp statute does not require you to provide permanent modified duty, especially if it's not something that you already have available as a job within your structure. Now, the ADA, you may have to provide a reasonable accommodation. I'm going to pitch it to you. I don't think permanent modified duty is a reasonable accommodation under the ADA, but I'm going to let Christine answer that.
Yeah, I was just going to say, your answer, I'm sitting here cringing listening when you say you don't have to provide that, because under the ADA, there could be a requirement that you have to provide some accommodation, but it's going to be on a case-by-case basis. And you have to look at that as, you engage in the interactive process with the employee, determine what the accommodations are that they're seeking. And it can depend on the injury. I mean, there was a time years back where sometimes there were a lot of injuries you could argue was not really a disability, but the statute's been amended. I guess it was a while ago, 10 or so years ago, but under the ADA as it's amended now, I think almost anything can be considered a disability. It's very hard to get around that. So it's important, if you're consulting with your workers' comp attorney, it's to also consult with employment counsel when something like that comes up, to make sure that you're not running afoul of the ADA too, or sometimes the FMLA too.
Yes, and to add to that, if you decide to terminate the employee under workers' comp, just know that there is potential, there's the potential that you're inviting an employment claim. So under those sort of circumstances, you may want to consider settling that workers' comp claim and obtaining a general release of all claims at the same time to avoid inviting another lawsuit under the employment arena.
Yet another reason to buy all your insurance coverages from one company. Well, we can do it under work comp, and the work comp says yes, and the D&O says, what you guys want to do is call us and tell us, here's the situation, handle it. If we need to pay something, I'm not going to pay this work comp, it's D&O, handle it. So, I mean, when we're making that pitch, it's not just this stuff actually comes up. So, just another plug.
And let me reemphasize that, because this comes up from time to time when you do have organizations that split their coverage between different carriers. You might have a claim and you think you have reported it, but that coverage may fall under a different line provided by a different carrier. So you report it to carrier A thinking that that's where the coverage is, when in fact, due to the nature of the claim, maybe it's provided by the different carrier. and you never reported it to that carrier. And now that carrier is going to take the position that they never received notice, and you've lost your coverage. So exactly to Shane's point, it's very helpful to have one channel that you can report your claims through.
A good example, I guess, question here. So unloading a client from, I guess, a vehicle that's owned by one of our nonprofits, and in the process of loading and unloading, there's an accident, person trips, gets injured. Is that an auto liability claim, or is that a general liability claim? Josh?
Or is it a workers' comp
Yeah.
claim? It depends. It truly does.
If it involves your employee or a covered volunteer, I would say it's a workers' comp claim. And
If
it
it's
should
a client that gets injured.
If it's the client who gets injured, then obviously it wouldn't be covered under workers' comp.
Probably a general liability claim, could be an auto claim. It really depends on the creativity of the attorney bringing the claim. He's going to look at where the most coverage is.
So if you have
that's what it comes
carrier
down
A and
to.
carrier B, obviously what ends up happening is carrier A is going to try to say it's carrier on carrier B. Carrier B is going to say, no, it's on carrier A. And you run into that kind of a scenario. We had a question over there.
So I would agree 100% with Shane that having all of your license coverage makes it so much easier to call one number and figure out which policy to address, because that's what we have right now. So thank you, Shane, for that. It really works well. My question is outside of workers' comp, but within the ADA, we see now an upsurge of very desk requests from staff saying, their chiropractor, you need to expand this session time. So what are the employer's obligations to provide these very guests that range from $500 to $600?
So the question here is, there's a trend in requests from employees for accommodations for standing desk and moving desks, and what is the S as an employer's obligation to provide in terms of an accommodation, because these desks can range and get pretty expensive.
Yeah, I think that it goes back to that same analysis. If there's a medical reason for that desk, or to have a standing desk, and if they have doctor certification, doctor's information saying that there is a medical reason, if it's a reasonable accommodation under the circumstances, then yeah, it's something that you would need to engage in that interactive process. But it seems, aren't those sometimes not for medical reasons? I think that some
Well,
people...
is a chiropractor's note, is that considered a medical reason?
I think
Or
it
does
would
that carry
be.
as much weight as a doctor's note?
Right. I think it would be. Then,
physician's
and you don't want to get into a big debate over whether that person has a disability or not, or whether that's sufficient. I don't know how much those things cost. I think they're just $600 or $700 or something. It depends, on business too, whether that would be reasonable if every single one of your employees tries to start getting one. But it's the same process as far as making sure that you're listening to what they're proposing, and is there some other alternative, et cetera.
My biggest complaint about those visits, we've had like 3 requests from last month that you see the employees don't use them at all. They're still sitting there, not raising them up, they're not standing. And we know that they're going to complain and file more complaints about it being workers' compensation.
It's like a gym membership. All right, since Florida is an at-will state, doesn't that mean an employee can be fired for any reason, and the employer does not need to provide the employee with a reason for termination?
I love that question. I'm glad we're ending with that. I do love that question. Well, because I think most of us probably figured out by now, just because it's an at-will employment state, yes, you do need to have a reason. There's so many exceptions to the at-will rule. There are so many statutes that somebody can bring a lawsuit under. We talked about earlier about the retaliation, whistleblowers. Somebody could say, I think there's asbestos in the ceiling, and so I feel like something is illegal with that. That could be a whistleblower. So there's just so many exceptions to it that it's really, it is an at-will employment state, but there's a lot of ways that an employee can come up with a way to sue. So my biggest pet peeve, I think, is when I run into cases or employers who feel like they shouldn't give a reason for termination. I think that is a horrible idea. Please, if you remember nothing else I've said, please give a reason. Because my personal opinion, this is partly based on my experience and legal, but people in general, when they are terminated, if they are not told why, or if they haven't been given warnings leading up to it, they're going to come up with some other reason. They're going to say, oh, it must be because I'm female, or it must be because I complained about something. But if you give them a reason, even if you feel like you're being mean, it's just so important. And I think that could help employers. I think that could help employers avoid future lawsuits in a lot of cases that I've seen. So.
So words of wisdom about emotional support animals and residential facilities.
You're the second one who has just come at me with an emotional support question. And so it's funny, I was talking with my colleague about it at work, and I think that it's going to be the same analysis, and it's going to depend on the situation. It's a case-by-case basis on whether that is a reasonable accommodation. And remember, there's a difference, too, between emotional support and service animals, I think. So I think that is also something that is going to be a big consideration. I don't know if you've had any experience, either one of you, with that.
I have not, but what comes to mind in your setting, if you have residents, if you have a residential program and you have an employee or even a resident who wants to bring an emotional support animal, how does that impact? What if you have someone else in the home that has allergies to that emotional support allergy? How do you justify the needs of one versus the other?
What?
Rats as an emotional support animal?
Rats as an emotional support.
On a leash?
Wow.
Please, I hope they come in a carrier.
I just actually had to deal with that. We have a patient provides a stabilization unit, and a patient was brought to us by law enforcement, and then the family arrived with the alleged emotional support animal. We said, well, we need to see some certification of that, the qualifications of this dog. This is a small dog, I guess. Well, as a not necessarily an emotional support animal, from what I can see. And so what's the certification? And they held up a little card for the dog. So I said, well, let me see what the qualifications are. I went in and I registered, certified my dog within about 45 seconds. There was no qualification, no certification. And we said, unless you have a note from a physician, the dog can't beat them because we have health standards that we have to meet as well.
You're absolutely right. It's so easy to register an animal now as an emotional support animal. That it's reasonable to require a medical certification.
And so you get into a residential facility, with the health standards, now you've got staff who are saying, I won't come to work because I'm terrified of dogs, so I have to call out. They've got rights, so it's a complicated nightmare.
The residents too are complaining because there's dogs and what have you.
You have a wrap around.
Jeez. So how do you distinguish that between a service and a emotional animal? I mean, is there a way?
So on that issue, I know that oftentimes when you're looking at things from an employment law perspective, if you can show a non-discriminating reason, say with your background and your drug screen and those types of things, non-discriminating reason, that you cannot allow that, especially in residential. We have policies in place to support that. Is that somewhat of a defense, strong, weak defense?
Yeah, and I think I think at the end of the day, if you have a non-discriminatory reason for implementing policies like that, and if you're consistent in implementing them, it's probably going to be defensible. But it's such a risky area because you could have somebody there who says, that that's not fair and that's because of my disability, et cetera.
Explored this a lot. The
Right.
Only the emotional support falls under the fair housing. And so that's where the rules will allow what you have to accept and what you don't. And put some barriers in place to make it more difficult for somebody to get through, but it's very clear what you can and cannot ask and what you can and cannot deny. So it's the fair housing, it falls under the emotional support.
Right.
ADA does not recognize emotional
Right. That's correct. That's correct. She correctly just was pointing out the ADA recognizes service animals, not emotional support.
Well, with that, I think we're kind of at that time. So thank you, panelists.